Council for Governor, the floor is yours.
May I proceed, Mr. Speaker, sir?
Absolutely.
Thank you so much, Mr. Speaker, sir, and thank you so much, distinguished senators. For the record, my name is Ongoya. I'll be making the governor's closing submissions. Distinguished senators, courtesy demands that I open this process by thanking this House for the opportunity given to us as council and the opportunity given to the governor to be heard as we have been heard. The challenges associated with the time notwithstanding, we are satisfied that we have had a fair day in this honorable House. Distinguished senators, the governor invites this House to be guided by certain enduring principles that she will draw the attention of this House to. The governor invites this House to be guided by the guidance that was supplied by the famous philosopher Socrates to all persons sitting in the position of judges, which you now do. 4 things belong to a judge: to listen courteously, to answer wisely, to consider soberly, and to decide impartially. There is a biblical injunction that also addresses itself to the attributes of judges. I think there's advice that was given by a man called Jethro to a man called Moses in the book of Exodus, when Jethro thought that Moses was spending significant amounts of time deciding cases. He advised him to appoint judges to help him decide disputes between the children of Israel. He gave the following attributes: able men, such as fear God, men of truth, hating covetousness. The governor holds this Senate in the highest possible regard and attributes these attributes that have survived the age of time to this Senate. Allow me to deal with what I consider to be some side issues that have arisen in the course of this trial and in the course of the Assembly's final submissions. Distinguished senators, an issue emerged as to whether ISPAC member number 10955, Kirimi Ibrahim Mutwiri, is an active member of ISPAC in good standing. Fortunately for us, like many other professional bodies, the data of many of us professionals is now available in the public databases of the respective professional association. Any senator who cares to search member number 10955 on the member search engine of ispac.com will get a chance to satisfy themselves as to the active status and good standing status of that member. I repeat, member number 10955. Each senator is at liberty to search on the website ispac.com/search-member to establish for themselves the standing of that member. I say that with great humility because it's important that we address ourselves to the substantive issues that have kept us here and that keep us here up to now. It is not for lack of other business, the governor believes, that distinguished senators are sitting in this House after 9 p.m. to resolve this dispute. The governor believes that the issue before this Senate is so significant that it should never turn on a matter of side issues. And once senators search member number 10955 in the ispac.com search engine and establish the active and good standing status of that senator, of that accountant, my apologies, they will then form their own opinion as to who is standing on the platform of truth and who is standing on the platform of lack of truth in the conduct of these proceedings. Mr. Speaker, sir, I'll beseech the timekeepers to remind me at intervals of perhaps 15 minutes because I like managing my time as I get along. It's just my humble plea. Mr. Speaker, sir, distinguished senators, impeachment processes, as I have said before, are processes governed by law and legal principles. It is now settled by no lesser authority than the Supreme Court of the Republic of Kenya that public participation is an important pillar of the impeachment process. It therefore means that if an impeachment process is undertaken on a foundation of lack of proper public participation, then that particular impeachment process cannot stand the test of scrutiny. I want to take these senators through the public participation report in volume number 5 of the County Assembly's documents so that these senators in themselves can ascertain whether that principle was satisfied. If the senators can access volume number 5, the largest possible volume of the County Assembly's documents, I'll beseech them to look at page number 35 of that document. Page number 35 of volume 5. It's the biggest volume in the County Assembly document. And if you look at page number 35, there is a photograph on that page which is supposed to be a photograph of the members of the public attending a public participation function at Abogeta West Ward. I then, distinguished senators who have seen that photo, beseech them to look at page number 30 of the same volume. Page number 30 of that volume, which is supposed to be now the public participation event at Abogeta East Ward. On the face of it, the same people in the same sitting arrangement taking the same posture at page number 30 at Abogeta East Ward are the same people in the same sitting arrangement taking the same posture that you'll discover at page number 35. I leave it to your able judgment about what that says of the integrity of this public participation process. But that's not enough. I'll beseech distinguished senators to turn to page number 331 of that same document. 331 of that same document. May I urge that we start at page 330 for proper context. At page 330 is a title of minutes showing that this should be a public participation event at Akirangondu Ward, in Akirangondu Ward at Machungulu Social Hall. I'll beseech distinguished senators look at minute number 3, which runs from page number 331. And I want you to look at the entire of that minute from where it starts all the way overleaf to page 332. To make my point, I would ask the senators, while keeping their finger on that minute, to turn to page number 373 of the same bundle. While keeping a finger on this page 331, to turn to page 373 of that bundle, they will see that these are supposed to be minutes of a public participation function in Meru ward at a place called Kimiri MCK. These are supposed to be events done on the same day at the same time. You realize that minute number 3 of those minutes starts at page 374 and turns over leaf to page number 375. These minute takers somehow meticulously used the same words word for word across 1.5 pages of minute taking of an objectively taken set of minutes. Distinguished senators, while at it, I want you to turn to page 390 of that same bundle. When you turn to page number 390, you'll come across a public participation event that apparently took place in Igembe East Ward at a place called Karaune MCK. And just for comparison, I will then urge you to turn to page number 393. 393, which is supposed to be a public participation event in Adiru Rujine Ward. I try to understand how to pronounce this name in Meru language, a lot of difficulty. Adiru Rujine Ward at a place called Akune MCK. Putting your finger on those 2 minutes, I want you to look at minute number 3 of each of those 2 minutes. The one at page 390 starts from page 390 through page 391 all the way to page 392. And the one starting at page 393, minute 3 starts at page 393 through page 394 all the way to page 395. And you'll discover those minutes use the same words in the same order, the same sentences in the same order, word for word, across 3 pages of minutes. I leave it to able judgments, applying this Socratic standard that I have just prescribed for this sentence. Courteously, you answer wisely, you consider soberly, and you decide impartially, distinguished senators. Would you say that this is a public participation process that passed the requisite test of integrity? I just want to demonstrate one thing which can be done without taking too much time, which is page 332 of that document. At page 332 of that document, which is part of the minutes of a public participation event taking place at in Akirangondu Ward at Machungulu Social Hall, at minute number 4. At minute number 4, you'll come. Sorry, my apologies. I want us to go to page, my apologies. I misled you when I referred to 332. I want us to refer to 370. Let me see whether this brings out the point, then I can conclude just that we don't waste a lot of time. Let me look at 373. If it doesn't, I'll just go to the next minute, then we clear that in a short while. Yes. Thank you so much. That is the one. I wanted to look at page 332, minute number 4 at Akirangondu Ward. The minute taker says as follows, members of the public upon equal and fair representation from across the locations in the ward ended the meeting at 1 p.m. full stop. A member of staff from the county assembly gave closing remarks and thanked the members of the public for exercising their constitutional mandate and conducting their exercise peacefully and inclusively. When you go to page number 375, which are minutes of a completely different ward, you also see minute number 4 in Meru ward, where members of the public upon equal and fair representation from across the locations in the ward ended the meeting at 1 p.m. A member of staff from the county assembly gave the closing remarks and thanked members of the public for exercising their constitutional mandate and conducting the exercise peacefully and inclusively. The same minute, the same words in the same order. I spoke here about some things being too fantastic to be true. Distinguished senators, these are the sort of things I was referring to. Normal human fallibilities militates against this kind of coincidences. I'll briefly make that point by looking at page 392 at page 392 of the minutes from Igembe eastward. Page 392, after Roman 11 up there, there is an entry, a lady who spoke and was not in support of the impeachment motion said that since the governor was a woman, the MCAs were planning to impeach out and needs to give her time to work and complete her term. It follows, another one said that she doesn't support the impeachment motion because the governor is the only senior most politician from Meru County. I want us to turn to page 395, which is part of the minutes from Adhiru Rujine ward. Just after Roman number 11, a lady who spoke and was not in support of the impeachment motion said that since the governor was a woman, the MCAs were planning to impeach her out and needs to give her time to work and complete her term. It follows, another one said that she doesn't support the impeachment motion because residents of Meru County are tired with these unending fights between the governor and the MCAs. Distinguished senators, I leave it to your able judgment as able men, such as fear God, of truth, hating covetousness, using this standard of Jethro as he advises Moses, to determine for yourself the quality of public participation that underwrites this motion. We are looking at a document that is 1,344 pages. Time cannot allow us to continue with this kind of analysis, but the point has been made. Allow me to move to the next point. I want to deal with the various allegations that have been made against the governor in this impeachment motion. If you look at the impeachment motion at count number 1, the governor is accused of gross violation of the Constitution and other laws, and a general allegation of violations of laws is made there. The burden for us is to establish whether the ground in support of that allegation has been made. I would start by dealing with ground 4 for good order. I will deal with the other grounds as I carry on with these submissions. The governor is accused of dismissing Dr. Ntoiti, Paul Mwaki, Kenneth Kimathi Mbae, and Joseph Kithure in usurpation of the powers of appointing authorities. The mover of the motion was taken through this ground as against what was count 4, paragraph 16 of the motion that was before this house in November last year, my apologies, in November last year. She confirmed that there has been no new action on the part of the county government in respect of these officials. She confirmed that what she was complaining about here is the same action that informed the previous allegation in the previous impeachment motion. While at it, and so that I don't revisit this question, I also deal with count number 3, paragraph 3 of the present motion, where the governor is accused of employing a bloated workforce of at least 111 personal staff in her office. The mover of this motion came here and she conceded that this was the same allegation in count number 4, paragraph G of the motion that this Senate dealt with in November last year. The question I want this Senate to grapple with is this, and this is a question of principle. Is it permissible for this Senate to be called upon to re-debate the same fact over which it debated and acquitted the governor? Is it permissible in law? Is it permissible in good sense to re-debate and make a decision on it? Are these grounds you are going to vote for, or are these grounds in your private discussion and deliberation are going to move that must be struck out first before you consider the residue of the motion? That's something that I invite this Senate to grapple with so that it guides future processes of this nature. I'm making out an argument that the governor invites this Senate to take a position on allegations that have been debated here in previous impeachment motions and in respect of which the governor has been cleared of the same. May I draw the attention of this Senate to the fact that the move of this motion confirmed that in respect of the claim of employment of a bloated workforce, the same list of employees in the same order that was presented here in November last year is the same list of employees in the same order that she has presented here today, and sought that this Senate reviews its previous decision and enters a different decision from the one it entered last year. The second set of matters that I want to deal with is matters that are pending active litigation in court as we stand here today. What I'll describe as matters that are sub judice. Count number 1, paragraph 1 of the impeachment motion alleges that the governor illegally revoked the appointment of CPA Virginia Kawira Miriti as CEO of the Meru County Public Service Board. Distinguished senators, it is not in dispute that this matter is pending active litigation as Meru Employment and Labor Relations Court, case number E002 of 2024, Virginia Kawira Miriti versus the governor, Meru County. The governor invites this court to consider as a matter of principle what is its policy on matters sub judice. What is the policy of this Senate on matters that are pending active litigation before other competent institutions of dispute resolution. No problem. Evidence of the pendency of that case has, of course, been supplied in volume number 2 of the governor's documents at page number 14. Another matter that the governor wants you to apply the same mind on, that is matters that are actively pending in court, is what I referred to earlier as count number 1, paragraph 4, on the alleged illegal dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Mbae, Joseph Kithure Mberia. In addition to the fact that this is a matter that this Senate has already applied its own mind upon and made a decision on, it is not in dispute that this matter has been and continues to be in active litigation in our court. This matter went into court as Meru Employment and Labor Relations Petition number 1 of 2022 and is now pending an appeal. Evidence of the pendency of that appeal process is at volume number 7, at page number 71, volume 1B of the governor's documents. Again, distinguished senators, with tremendous humility, I invite this House to take this as a question of principle. What is the policy, the legal policy of this Senate on matters that are actively pending in our courts, such as ground number 1, sorry, paragraph 4, count number 1 of this impeachment motion? If you look at ground number 2, paragraph 6, and ground number 3, paragraph 11 of the impeachment motion, that motion, just for good order, is in the County Assembly's documents, volume 1. This is the matter relating to the alleged, or the case of murder of one Daniel Muthiani, alias Sniper, and contributions towards his family, and the role, connection, or status of Kiambe Crispius Manyora, an accused person in that murder. The County Assembly, at volume number 2 of its documents, at page 429, has supplied this House with the charge sheet for that murder case. Distinguished senators, I beseech you to again make a principled decision in a matter such as this, where the County Assembly by its own documents admits that it's a matter pending active trial in our murder court, our high court. What is the policy of this Senate towards matters such as those? I submit that this is a matter of principle, because this should be able to guide future impeachments, so that we don't have to revisit these questions of principle. People can be guided by the decision of this Senate once and for all. Finally, the impeachment process itself in its entirety, I wish to refer you to volume number 2 of the governor's document at pages 28 to 32. At page 28, you can see Meru Constitutional Petition number E013 of 2024. The parties to that case are Honorable Kawira Mwangaza, petitioner, and the County Assembly of Meru, respondent. The two parties now appearing before you and represented by counsel, as has been the case. If we turn to page number 31 of the Governor's volume number 2, there is a ruling of court which says the upshot of the above is that the impeachment process is halted pending my ruling, and since this matter is of public interest, the ruling on the interested parties and the main petition will be delivered on 29th July 2024 via email to all parties. It is in the public domain that that ruling was not delivered on that day and is still pending delivery, and this order remains in force. As a matter of principle, I invite senators to reflect on this question, because the governor has been brought here by the county assembly claiming that it wants to strike a blow for the rule of law. And yet we are here debating this matter in the face of an order reading, and I quote, "The upshot of the above is that the impeachment process is halted." As a matter of principle, distinguished senators, what position do you want to take on this matter? You are the judges. You will make the decision one way or the other. I have done my part as legal representative to my clients. I have made full and candid disclosure that we may be perpetuating a violation of the rule of law. We may be. I am not the decision maker. I leave the eventual decision to your able hands, distinguished senators. Is this the way we shall grow our institutions? If a court of competent jurisdiction can make an order such as this, the county assembly proceeds in violation of this order. The governor has told you on her part, she has taken some action on this violation, and at page 35 onwards, you will see a contempt of court application that she has filed. She has done her part. The court will deal with that. Shall we, sitting here in good conscience and our attention having been drawn to these facts, perpetuate this process which on the face of it the county government has undertaken in violation of a valid court order? It is not for the governor, it's not for her council to make that decision. Distinguished senators, the heavier task lies with you to make a decision one way or the other on these questions of principle, touching on those specific paragraphs of those specific counts that I have alluded to, and on this impeachment process as a whole, as I have drawn your attention to page 30 of volume number 2 of the governor's documents. Let me proceed by addressing you briefly on the Public Audit Act. Distinguished senators, I beseech you as you make this decision this evening to be guided by the provisions of section 53 and section 54 of the Public Audit Act. I say this in summary in response to the multiple audit questions that have arisen in the course of this hearing. Time will not permit me to point at specific audit queries. Having been present here, we know those audit questions. Section 53 of the Public Audit Act has a side note entitled Implementation of Reports. These are audit reports by an accounting officer. Implementation of reports by an accounting officer. Subsection 1 of section 53 of the Public Audit Act provides, and I quote, "The relevant accounting officer of a state organ or public entity shall within 3 months after Parliament has considered and made recommendations on the audit report. So first, there is an audit report. 2, there is parliamentary consideration of the audit report. Then 3, there are actions to be taken, which are take the relevant steps to implement the recommendations of Parliament on the report of the Auditor General, or give explanations in writing to Parliament on why the report has not been acted upon. The law itself actually anticipates failure to act on those reports with reason. Honorable Senators, there is a principle in law called the subsidiarity principle. The subsidiarity principle in law dictates that a dispute must be resolved at the lowest institution competent to resolve it. So, for example, as a litigation lawyer, if I have a case that can competently be handled by the High Court, but when I look at the law, it can also competently be handled by a lower court, a magistrate's court, I am obligated to file that case in the magistrate's court, which is the lowest court competent to hear that dispute. We now know that the County Assembly of Meru has not exercised its mandate by seizing these reports and making necessary recommendations or steps to be taken to implement the report. Instead, it has picked the reports and come to this house with those reports. I want to believe, speaking for myself, that that is overburdening this very busy house. I want to suggest to you, senators, that if you set a precedent here in these proceedings, that a county assembly can do that, it means that if we get a year where there are 47 county governments with some issues, and you know better than I do that virtually every year, every county government has some issues in the audit report, it is possible for county assemblies to bring here 47 impeachment motions. I suspect that that may break the functional machinery of this house. I think that you better take a position in this matter that reminds county assemblies that they also have a role to discharge. To sit, invite relevant officers of the executive, interrogate audit reports, resolve disputes that can resolve there first, then come here with only such residues of issues that the relevant officers have proved to be incorrigible. That is my humble submission, distinguished senators. There is a cadre of